trying to bring back that neutrality to all ballot measures. Make sure that the ballot title for any ballot measure, any initiative, any referendum, whether liberal or conservative, is neutrally worded and not create bias. The language of the initiative repeatedly uses the term government description. Repeatedly throughout the initiative, it defines what a government description is, and those are ballot titles, summaries, and public investment impact disclosures. Hereafter, I'm just going to refer to those as disclosures, because it's a tongue twister otherwise. Those descriptions should all be neutral because they're all part of the ballot title. That's what will appear on petitions, on ballots, in voters' pamphlets. With some initiatives, there's so many things going on that in the 10-word statement of subject and the 30-word concise description, there's just not enough words to describe everything the initiative does. In this case, this initiative is very straightforward and has very straightforward essential contents. It says any government description that appears on petitions, ballots, or voters' pamphlets has to be neutrally worded and not create bias. It concerns state initiatives and referendums. And then finally, it allows an expedited court decision on any legal challenge to one of those government descriptions. Let me start with the last part. The ballot title proposed by the Attorney General says, proposes, I should say, and make changes for legal challenges related to ballot measures. Make changes. The initiative specifically says any challenge to a government description will be expedited by the court. The court will make an expedited court decision. The word expedited is defined as within 7 days. This court, by my research, since 1960 through 2017, would make a court decision on a ballot title in 5 days, because the law said shall take first priority and within 5 days make a decision. In 2017, the local rules were changed and allowing now the process to be elongated quite dramatically. I have seen ballot title challenges last between as high as 45 days and as little as 20 days. Your Honor ended up being on the low end in this particular case, but I have seen them last that long. This initiative seeks to have expedited court decisions. And so what I've proposed in the alternatives is require expedited court decisions when descriptions are challenged. I've offered Your Honor third amended order proposed 3 different options, but all of them basically on that last point. Require expedited court decisions when descriptions are challenged, or require legal challenges be expedited, or require certain court decisions be expedited. The Attorney General says that the alternatives that I proposed aren't precise enough or aren't as precise as what they've proposed. I would argue that make changes for legal challenges related to ballot measures, the average voter is not going to know what those changes are, and they're not going to know how they relate to ballot measures. And the alternatives that I proposed just for that last part, to me, seems much more precise and much more informative to the average voter. So I would encourage the court to consider that change to the ballot title related to just the fact that you're going to decide this stuff within 7 days. In 7 days, this court is going to do it. As an added benefit, to Your Honor, there's been a proliferation since 2017 of ballot title challenges, which ties up the court's time a lot. Back in the good old days, and I dare date myself, but I remember before Judge Hicks back in 2001, it was within 5 days. And Judge Tabor, same thing. Judge McPhee, same thing. 5 days they made a decision. It got over with quickly, and there weren't as many challenges because there was no incentive for the opponents to drag things out. So added benefit to the court, under this measure, the court decisions will be expedited. Now let's get into the meat of it all. You have 40 words to work with, 10 in the statement of subject, 30 words in the concise description. The alternative that I proposed allows voters to know where these government descriptions will be found. Petitions, on ballots, and on voters' pamphlets. That is, by my count, I believe like 5 words or 8 words, something like that. Out of 40 words, I think telling people where they're going to get this information is important, it's more precise, and it doesn't keep the voter guessing on where they're going to receive these government descriptions or information. The other thing that the Attorney General felt important was to use the words presented to voters. It doesn't appear anywhere in the initiative, those words, but I have no objection to including those 3 words in the ballot title, because it's only 3. So you're not using up a lot of real estate for that. Both of us are saying you should mention the fact that these are state initiatives and referendums, as opposed to local ones. That only takes 4 words. The big fight, I believe, relates to the idea of, they argue that you shouldn't even mention ballot titles or ballot summaries at all. We should only focus on public investment impact disclosures or disclosures. The reality is, I could see the argument if there wasn't enough real estate to be able to include those others. But the initiative specifically says, when we say government description, we mean ballot titles, summaries, and these disclosures. There's enough room to include all 3 of them. So why not inform the voters where this information is going to be presented, get rid of this, where they're going to be, the fact that they are from state initiatives and referendums, and the fact that they have to be neutrally worded, and we don't quibble over this language, be neutrally worded and not create bias. The criticism that I saw in the Attorney General's brief was that the versions that I'm proposing are not as precise as theirs. I can't get my mind wrapped around why the word information, which is a very vague term, is somehow more precise than a government description. But literally in the last, I'm approaching the 9-minute mark, over the weekend, and the reason I proposed 3rd amended order, if they have such a problem with the word government description, the 3rd option on page 2, before your honor, avoids that concern. Statement of subject, initiative measure number 884 or 195 concerns information presented to voters on petitions, ballots, and voters' pamphlets. Uses all 10 words. The concise description, this measure would require state initiative and referendum ballot titles, summaries, and reworded public investment impact disclosures be neutrally worded and not create bias, and require expedited court decisions when challenged. Reworded and neutralized is used 30 times in the initiative to preface the words public investment impact disclosures. That's what the initiative does. It rewords them. It rewords them in a way to make them neutral, because within the ballot title that voters are voting on, this current wording is inherently biased. The words "this measure would reduce funding for," that mandatory language, is unambiguously putting a thumb on the scale. And the thing I've heard for 29 years from the Attorney General's office, as well as every judge I've ever been before, is ballot titles are not the forum for us to be describing the downstream effects of an initiative. That's what the campaign is for. The ballot titles describe what the measure does, and it's the campaign's obligation to describe the downstream effects. And if it's a tax initiative, the people who are for reducing the tax say this will lower your taxes. The opponents of it say this will cut government programs. Both of those are true, but that's what the campaign is for. The ballot title, however, should be neutral and not create bias, and the proposed in the initiative says the government's estimated impact of fiscal impact in this measure appears in the voter's pamphlet. Unambiguously neutral, doesn't put the thumb on the scale, plus or minus. As my wife has correctly pointed out, I was supposed to go for 10, I went for 11:45, so I'll have 3 or 4 minutes to rebut this gentleman.
All right, thank you.
Thank you very much, Your Honor.
Let me ask you one question before
Please.
I hear from Mr. Smith. In your proposed number 1, you refer to appear on petitions, ballots, and voters' pamphlets. Would those items be properly described as ballot materials? Well, actually, this.
I would quickly say,
Nope, just
no
a moment.
voter will
Please
know
stop.
what. Oh, I'm sorry. I thought you asked a question.
I did.
My fault.
I'm going to let you think about it,
Fair enough.
because I do want you to think about it, because that is a term that I am thinking about. I don't know whether or not that accurately encompasses those 3 things. So you think about that. I'm going to hear from Mr.
Fair point.
Smith, and then I'm going to come back to you.
Thank you
Okay?
very much.
Mr. Smith,
Your Honor, may I present from the podium?
you may.
Deputy Solicitor General Carl Smith on behalf of the Attorney General's Office. I want to start with 2 preliminary remarks that Mr. Eyman hinted at, but I just want to spell it out a little bit for the court. First is these 2 measures before the court are substantively identical. There is some different wording. The voters and voters pamphlet is possessive in 884 and not in 095. There's the reworded and neutralized terminology in 884, but not 095. But substantively, in terms of the difference they make to state law, they're substantively identical. So I think it made sense that Mr. Eyman combined this discussion, and I'll combine my discussion as well. The second preliminary remark is that Mr. Eyman is only challenging the ballot title here today, not the summary. So we're only talking about statement of subject, concise description. So I think the right place to start for both of those is to start by identifying the measure's essential contents. Because as Mr. Eyman acknowledged, that's what the statute charges us with describing in the concise description, and then that informs what is the subject of the measure that's going to go in the statement of subject. So the essential contents here really break down into 3 categories of things. The first, and I think the most significant change from existing state law, has to do with the change to the public investment impact disclosures. Under existing state law, the public investment impact disclosure appears on the ballot for voters, and it indicates how the measure would, if it was passed, affect existing public investments. How would it affect the general fund? How would it affect other specific funds? And that measure goes right on the ballot itself. We provided an example in the briefing of Initiative 2024, 2024. This measure would change that. It would change it to just a single sentence that's written out in statute that Mr. Eyman identified, and it would say that the government's estimated fiscal impact appears in the voter's pamphlet. So it changes in a very significant way the information presented to voters on the ballot. Now, Mr. Eyman thinks that's appropriate. He believes that that eliminates bias. Other people might think exactly the opposite, that to only describe the contents of the measure but to not describe the downstream effects would create bias. And so that was the legislature's view. Now, reasonable minds can differ. It's not the role of the Attorney General's office to decide that. It's not the role of this court today to decide that. The important thing is it's part of the essential contents that need to be reflected in the concise description of the measure. So the Attorney General's office's concise description does precisely that. That's the first clause of the concise description. The second category of essential contents has to do with the provisions regarding neutrality and avoiding prejudice. Now, as we laid out in the brief, that is already required under existing law. If we wrote a statement of subject that introduced bias or prejudice, I would expect this court to alter that statement of subject. The same thing for the summary. But we agree that it's a part of the essential contents because it takes an implicit prohibition on bias and makes it explicit under the law. So the Attorney General's office agrees that that's part of the essential contents, and the Attorney General's office's concise description includes that. It says that the measure would prohibit bias in certain information about ballot measures. The third category of information, the third category of essential contents has to do with the changes that are made to challenging ballot titles and public investment impact disclosures. So there are two here. Now, Mr. Eyman highlighted the main one, and it's much more significant than the other, which is that it would require an expedited decision on the measure. And while it changes the number of days from 5 to 7, the key part is what follows that when it says that it would be within 7 days of filing the petition itself. The other change to the process, and this, again, I agree, this is much more minor, is it requires service of a challenge on the public investment impact disclosure on the Office of Financial Management. That doesn't exist in state law. It would. And the reason for that is that under this proposal, those public investment impact disclosures would be written by the Office of Financial Management instead of the Attorney General's office. So that more general terminology in that third clause about changes for legal challenges related to ballot measures, that was intended to capture both of those changes, although again, I recognize that the expediting has a more substantial effect than the new service requirement created by the initiatives. So the Attorney General's concise descriptions all comply with the statutory requirements. They describe the essential contents of the measure, and this court should affirm that. Similarly, with respect to the statement of subject, the Attorney General's statement of subject is broad enough to capture everything within the measure and is sufficiently precise in identifying the what, the descriptions of the information presented to voters about state initiatives and referendums. So I want to briefly respond to Mr. Eyman's 3 alternatives that he includes in his most recent proposed order. These are different than the 2 that were in his reply brief, but I'm working on the understanding that these are the ones he's currently advocating. So that's what I intend to respond to. So I'll start with the statement of subject and the concerns we have about the statement of subject. So in the first 2, the statement of subject for 1 and 2, they both use this phrase, government descriptions presented to voters. The problem here is that government description is a defined term of art in the measure. And if you take a step back and you actually look at, this is the 8th version, these are the 7th, I believe the 7th and 8th versions of the same type of initiative. And many of them describe government description differently. Some include explanatory statements that appear in the voter's pamphlet. Neither of these 2 do. Some include fiscal impact statements. Again, neither of these 2 do. This illustrates that government descriptions is not a term that people are going to recognize. It's going to depend on the definition of the statute. So that's why we opted for the more general term information that puts voters on notice to inquire into the measure to find out what information. So that's why we think that government description isn't a good term to include within that statement of subject. Government description is also a poor fit for referring to the public investment impact disclosure. As Mr. Eyman's final comments there highlighted, the public investment impact disclosure isn't about describing the measure. It's about identifying the impacts to public investments. So it's looking forward, it's not describing the measure. So it's not quite accurate, I think, to call it a government description. I don't think it would run afoul of any constitutional requirements. I just think that sticking to information is better for providing information to voters in this context. With respect to the third statement of subject, that one does not use the term government description. So this one's closer, but we still see 2 problems here. The first is it talks about the where but not the what. So it refers to government descriptions presented to voters on petitions, ballots, and voters' pamphlets, but it doesn't say about what. Whereas the Attorney General's proposal says about state initiatives and referendums. We think that does a better job of conveying the subject, and that's why we'd ask the court to maintain the existing statement of subject. Turning to the concise descriptions that Mr. Eyman's offered, for the first 2, the specific concern we have is that it doesn't give voters adequate notice of the changes to public investment impact disclosures. As I discussed a little bit ago, that's a key part of the measure's essential contents. Whether one supports public investment impact disclosures or opposes them, this is a very significant change to state law. There needs to be notice of that in the concise description. And the first 2 just don't get at that. Again, that use of the descriptions isn't good enough to put voters on notice to inquire further, to learn that they will not be receiving the same information on the ballot that they previously received in 2024. With respect to the third one, again, Mr. Eyman's third alternative I think is closer, but still not adequate notice here. It mentions public investment impact disclosures, but it suggests that the only change is to require neutral wording and prohibiting bias. But that's a bit misleading because it changes the information that's presented. Now, Mr. Eyman's of the view that the public investment disclosures are inherently misleading and biased, and so it would put him on notice. But for voters who don't consider those to be inherently biased or misleading, it wouldn't be good enough to put them on notice that there are changes to public investment impact disclosures. So that's why we prefer to say that it makes changes to public investment impact disclosures and let voters inquire into what those changes are. Better to be open-ended than misleading. It's the general concept of why we think that's appropriate. Now, you'd asked Mr. Eyman a question about the use of the term ballot materials.
In a way to whether or not that would, just a moment, whether or not that would describe petitions, ballots, and voters' pamphlets, whether or not that terminology could encompass those things. That was my question.
Yeah, and I don't think that captures the petition sheets we're talking about here. I think when people think about the ballot, they might think that might capture the voters' pamphlet materials that describe the things that are on the ballot. But at the time we're talking about the petition to put something on the ballot, it may or may not make it to the ballot. I don't think that would be descriptive enough to put voters on notice that this would affect what appears on the petition sheets.
All right, thank you. Mr. Eyman?
What's made this particularly challenging is Carl's an incredibly likable individual, and I'm not used to that in this office, so it's been difficult to have him as an adversary. He's so polite. Let's look at the third option proposed in the orders of the three of them, because as he keeps saying, it is the closest to where we want to get to. And I agree with him on the ballot materials thing not being really appropriate for a petition. It puts voters on notice that there's going to be information presented to them on petitions, ballots, and voters' pamphlets. That's where they will see this information. It's broad. It is very broad. It doesn't use the word description, which they take offense at. The concise description requires state initiative, referendum, ballot titles, summaries, and reworded public impact disclosures. Truth is, there is a substantive change when it comes to ballot titles and ballot summaries. There is I would call it a loophole in the law, which the initiative strikes out, that says cannot reasonably be argued creates bias. It strikes that out, says there will not be bias. We've seen, I won't get into it, in the briefs I highlight kind of a disparate treatment of the AG's office when it comes to initiatives. I'm not going to get into that right here, but let me just focus again on the word reworded public investment impact disclosures. Let me quickly add, no one's going to know what a public investment impact disclosure is, but it will put them on notice that they've been reworded. It will include all three government descriptions, titles, summaries, and these disclosures. I think we agree, sounds like, we're agreeing on expediting court decisions when these things are challenged. So I think we're really focused in on the reworded public investment impact disclosures. Is that putting the voters on notice that they've been reworded? Yes, it's telling them they've been reworded. I looked everywhere. I could not find the court case. Maybe Carl knows it off the top of his head. Some court case says many voters will make their decisions based solely on the ballot title, and that's what makes the ballot title so crucially important, that it be neutrally worded and not create bias. But for it to be informative, where you don't have questions that you have to have answered. Your Honor has said she's read all the materials. I have no doubt that you did. Many voters will make their decisions solely based on the description, And if their sole criticism of this ballot title, with 6 seconds left, if their sole problem with it is it's not precise enough, I would argue that the third option presented to you, both for both initiatives, is dramatically more precise because it specifically names each of the descriptions, doesn't use the word description at all, and does it in a way that's completely neutral and the voters are given notice. This initiative has essential contents. Why hide them? Why not have them be explicitly in there rather than using these vague terms? Appreciate your consideration and the extra 34 seconds.
All right, thank you. So today, as it relates to the two different ballot titles that are in front of me because they were consolidated, 095 and 884, really as was indicated, I think by both parties, the substantive portions of both of those are really identical, and my ruling will apply to both of them. As to the statement of the subject, I find that the statement of subject as was proposed in the ballot title authored by the Office of the Attorney General is appropriate. The statement of the subject must be sufficiently broad to reflect the subject of the measure, sufficiently precise to give notice of the measure's subject matter, and not exceed 10 words. It fulfills all of those requirements. And that was RCW 29A72050. I reviewed the statement of the subject that was provided within the written materials that the court was provided, and then I looked at the third amended order as well today during argument, and I don't find that any of those statement of subject as proposed by Mr. Eyman are better than or make more sufficiently precise than what has been drafted by the state. I am, however, considering whether or not the concise description should be altered, and that is why I had asked the question about the wording of ballot materials and whether or not that was sufficient to cover the issues related to petitions, ballots, and voters' pamphlets. I'm going to read language that I am considering. Now, this is not my proposed language, but this is language that I'm considering. I'm going to read it into the record, and then I'm going to provide it to both parties in writing, and then I'm going to take a recess so that you can both look at that, and then I can hear any specific objections as it relates to this language, because I don't know that this is the appropriate language either, but as I was trying to address issues raised by Mr. Eyman that certainly appeared valid to the court, and consistent with what is required by the statute, because that's really what governs this, not whether or not one side thinks one thing or one side thinks the other. The difficulty, as both Mr. Eyman and Mr. Smith know, is the 30-word limitation, and I think that my new version, based upon what I heard, because I now have some handwriting on what I had previously typed, is right at 30 words, might be 29. So this is the language, again, that I have been thinking about. The concise description. This measure would require neutral, unbiased language on petitions and ballot materials related to ballot measures. It also makes changes to public investment impact disclosures and legal challenges related to ballot measures. I'm going to provide to my clerk a copy for each of you. I'm going to take, I think a 5-minute recess is sufficient. If you want more time after 5 minutes, I would give you up to 10 minutes to look at this language. And again, I'm not indicating this is the language I'm going to adopt, but it is something that I have been thinking about after reviewing all of the materials, and I would like to hear from both of you as to any concerns, objections, how you think this may not comply with the statute and the like. Do you have any questions about that, Mr. Eyman?
No, thank you, Your Honor.
Mr. Smith?
No, Your Honor.
All right, I'll be in recess for 5 to 10 minutes. Thank you. Is appropriate. So I am going to adopt language. This measure would require neutral, unbiased language on petitions and ballot materials related to ballot measures, period. It also makes changes to public investment, impact disclosures, and legal challenges related to ballot measures.